Okay, I have 7 o'clock. Carl, we good? So we'll call to order the meeting of the Zoning Board of Review, Town of North Smithfield, Tuesday, December 13th, 2022. Roll call, please.
Mr. Najarian?
Here.
Mr. Martin?
Here.
Mr. Mark Antonio?
Here.
Mrs. Burlinghoff?
Here.
Mr. Marston?
Here.
Item 3 on the agenda, disclosure of no compensation or pension credits received by the board members. We are appointed by the town council and receive no compensation. Item number 4, disclosure and notice. Zoning Board of Review members shall disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before the Zoning Board of Review. Item 5, approval of the minutes from November 22nd of 2022. I know they were distributed in adequate time for review. Unless there are any additions, corrections, I can take a motion to accept.
I'll make a motion to accept.
Mr. Martin makes the motion. Second?
I'll second.
Mr. Marcantonio, all those in favor?
Aye.
Aye. Opposed? Minutes are approved. Item 6 is approval of the decision for Tech Realty LLC, 0 Central Street, ZBR 22-03. That made its way to you today. I believe everyone had a chance to read it. So unless there are any additions or corrections, I'll take a motion to accept the decision.
I'll make a motion to accept the decision for Tech Realty.
Mr. Martin, second.
I'll second.
Mr. Marcantonio. Tiffany, if you could, just call, might as well do a roll call vote. Only the members who voted on that decision, please.
Sure. Mr. Martin?
Yes.
Mr. Mark Antonio? Mr. Marston?
Yes.
Mr. Chairman, I didn't know that you weren't going to have 4, but I know that the statute provides that you must issue a decision within 30 days. I would ask that the board consider, if you think Mr. DeZiel could be available, I'd ask you to continue, you could continue this actual meeting to a date certain with, right now, it could be 2 days, 3 days. I mean, I know you don't have any way to contact him, but, and you could just come in for that one vote before I think it's the 20th. Is it the 20th? 22nd. So that's what I'd at least ask you to consider doing that. Otherwise, it's going to be a problem.
Well, the 20th would be a week from today. Yeah. You're not here that Tuesday. We can meet, you don't have to meet on a Tuesday.
You can meet any day before the 20th.
Or why don't we, is it, for those who can vote, is the 19th available to you? Okay. So why don't we'll move it to a date certain on the 19th.
Thank you.
Here?
Yeah, but the council meeting's at 6:45. Do you need to meet, 6:15? What time?
Well, we could meet at 6, literally, a 15-minute meeting. Call it to order, roll call, vote on the decision, and adjourn. Do we have enough time to post it?
Well, Yeah, all you need is 48 hours, as long as you continue to a date certain today.
Yeah, okay.
So if you continue, make a motion to continue this to Monday, the 19th at 6 o'clock.
I'll make a motion to continue, this to a date certain of, December 19th at, 6 p.m.
Second?
I'll second.
All those in favor?
Aye.
And the intent will be, so that we won't adjourn this meeting then?
Right, you'll continue the meeting. And the only point I would make to you, other than that, Mr. Chairman, is if you contact Mr. DeZiel and he's having a problem, you may have to actually continue that meeting to the next day or so. Hopefully, that won't be the case. You'll check tomorrow, and he'll be available on Monday for 15 minutes.
We'll get involved, Chris. And the other thing I want to follow up is to make sure that Mr. Pasquarello, whether his term is in fact up, I believe he sits until the new executive or the beginning of the new year. So we'll have to get in touch with Mr. Pasquarello and advise him to be present as well. Yeah, I don't believe that to be correct, but we'll get to the bottom of that to ensure that we have an acceptable quorum, minimum of quorum.
Thank you.
Okay, item 7 is new business. Item 7A is Island. Islander Solar LLC, Joseph and Sandra AUTHIER. Application request to discuss use permit, construct a solar voltaic system, 850 Iron Mine, 0 and 850 Iron Mine.
Mr. Chairman, point of order, I've just been informed by council that they've indicated the microphones are not picking up. I guess somebody is watching and they can't hear.
Oh, I may have had mine. Usually it doesn't matter, but I had, can they hear now?
Yeah, I can hear it now.
Okay, my mistake. I won't read, it's the application in its entirety. We can have counsel come up.
Are you gonna put anything in the record?
For what? Well, wait a minute, yeah, before we do. Did you want to, I want to introduce your articles, but did you want to make, counsel, did you want to make that one clarification that we had discussed before I introduce?
No, I think that we can go through it and I'll bring it up.
Okay, so let me introduce first, and then, sorry, I called you up prematurely. Multiple things going on here. So, P1, and again, this is for 0 and 850 Iron Mine. It's for a section 5.7.5A, solar photovoltaic system. It includes dimensional variance and the special use permits required for the solar. P1 will be ZBR application 22-5 dated 12/13/22. This is the standard Town of North Smithfield 14-page document that's provided to all. P2, I assume this went out with the mailing. It's a smaller copy of the notice, zoning board of review hearing notice. I'll call that P2. This was the announcement for tonight's meeting, specifically for this agenda item. P2A, I called it P2A, is the list of abutters that the announcement was distributed to. P3 is a quitclaim deed received for record on August 27th of 2013 with regard to 850 Iron Mine Hill Road. P4 is another quitclaim deed. This was received for record on 8/2 of 2021, and this is for, the address is, I don't see it, but it was submitted, so it's,
It's probably lot 19, Mr. Chairman.
yeah, I'm looking to identify it.
I think it's identified as 0 Iron Mine Hill Road.
Yeah, well, it's been submitted, so it's for the record. We can search for it, but it's part of the material submitted. P5 is a memo from ESS Group, Environmental Consulting and Engineering Services. It's dated January 7th of 2022. It's addressed to Mr. Charlie Roberts, Operation Manager, Project Manager for Island Solar. It's a 3-page document. And this,
It's actually four.
what's that?
One of them.
1, 2, 3.
Two pages.
Oh, it's 4. One is double. This is titled Carbon Sequestration Evaluation. That's the subject of that memorandum. P6 is also from the ESS Group. It's titled Noise Impact Assessment, Palmham Solar, which again is for the Iron Mine Hill Road. That's,
With the date.
the date is January 7th of 2022. We'll add the pages in a moment. P7, also from ESS Group, Environmental Consulting and Engineering, dated July 20th of 22, to Mr. Carullo, Town Planner, Planning Department, Town of North Smithfield. This is with regard to master plan application, and that's a double-sided 3-page, 6 pages in total. P8, an additional memorandum from ESS Group, also dated January 7th of 2022. Again, to Mr. Charlie Roberts, Islander Solar LLC. And this is environmental impact statement is the reference for Palmham Solar. And this is
9 pages.
9-page document, double-sided.
Some are double, some are.
P9, we'll call it P9A, because I believe it was intended to go with 9. Is 2 pages of pictures, photographs taken on September 14th of 2022. The only title is from TRC from 10 Hemingway Drive, East Providence. And again, 4 pictures of the solar photographs.
You gonna mention the date?
Yeah, I did. I did. September 14th. P10 is the drawing submitted by, it's prepared by, again, ESS Group, Environmental Consulting and Engineering Services Group.
Mr. Chairman,
It's dated January 7th of 2022, and it's a revision date of July 19th of 2022.
Mr. Chairman, you made a P9A, but there was no P9.
Yeah, I thought P9 was the,
Something from the ESS group?
oh, no, all right, so the photographs, we'll just call them both P9. So we won't have a P9A. That makes sense, yeah, because this is P9.
That's fine,
Yep.
thank you.
Okay, that's okay. And it's titled Palmham Solar Permitting Plans, Property off Iron Mine Hill Road, AP lots 16, 18, and 19. And it's civil drawings for the most part, and it goes from N1,
To
I don't-
D5.
how many?
D5.
From N, there's the table, yeah.
There's a bunch of letter ones.
Yeah, it goes from N1, which is notes, to site plan, radius map, and then the civil drawings, C1 through C6, and the detail sheets, D1 through D5. Okay, so we have everything entered into the record.
How about it was an email? Unbelievable, that came from. Is that for this, that's for this, right? Yeah. That came from Larry today?
Oh, I don't think I got that. Yeah, I don't have that. Yeah, all right, this will be P11. And this is from the Town of North Smithfield Planning Board decision letter dated June 7th of 2022. The reason I didn't include this is because this we already had it, I believe. This was with the appeal, but we can include it because it wasn't submitted by the applicant. But this is the Planning Board of Review decision letter from June 7th that then resulted in the appeal, which then came before the board acting as the zoning board of appeal. So it's not really relevant because it's already been dealt with, but since we received it, we can introduce it. So that would be P11. And I did make a copy for members' benefits. If there was any question as to what that appeal said, we do have a copy of the appeal. So now we can turn it over to council if you want to make the presentation for the board.
Thank you, Mr. Chairman. For the record, my name is Kelly Morris Salvatore. I am the attorney for the applicant in this matter. Just to introduce the matter, the property is located at 850 Iron Mine Hill Road. It consists of two lots. Number 850 fronts on Iron Mine Hill Road. It's Assessor's Plat 16, Lot 18, and owned by Joseph and Sandra AUTHIER. And the applicant will lease the access to a landlocked lot behind 850, which is designated Assessor's Plat 16, Lot 19. And as you just discussed, Mr. Chairman, we received master plan approval by way of an appeal to this board that you heard a couple of months ago. Tonight, we are requesting a special use permit for the solar facility and some variances in order to make this project feasible. Now, as the chairman alluded to earlier today, we had a discussion, I had a discussion with our engineer, and there is a provision of your ordinance that we're not quite sure how to interpret. But we want to ensure that we have any variances that may be required. So we're kind of belts and suspenders, abundance of caution, all of those catchphrases. So I'm going to go through the variances that we're requesting, and I'm going to talk a little bit about the one that we'd like to add, again, out of an abundance of caution. What I've asked Mr. Igliosi and the chairman to do is, after we make our presentation tonight, take public comment. We can continue this matter. We will renotice, just again, to make sure everybody knows what we're asking for, and we'll come back at your next meeting to make sure that there's no further public comment, and then you can deliberate and make your decision. So the variances that we're requesting are from ordinance section 5.75D. All solar arrays must be set back a minimum of 100 feet from the property line. And you're going to hear why we are requesting not to do that. In fact, it was the planning board's suggestion during their deliberations. Associated with 5.75D is 5.75G. This section actually references G, and again, out of an abundance of caution, we're going to be asking for relief from this provision, which requires that within that 100-foot minimum setback, a permanent all-season green buffer shall be planted. The green buffer shall be composed of evergreen vegetation. The green buffer excuse me, shall completely obscure the solar system and fencing from all neighboring properties. The green buffer shall be planted with mature plants so that the buffer is complete upon proposed startup of the solar voltaic system. The engineer is going to explain to you exactly what our buffer consists of, and there will be evergreen plantings. This provision of your ordinance is a little bit vague about how much evergreen planting you're supposed to do. So You will hear evidence tonight that it will be, the neighbors will be, the facility will be obscured. But we just want to make sure we cover our bases with regard to any variance that's required. Excuse me, I've had a cold for 3 weeks. The other variances are that, and again, this is kind of out of an abundance of caution. Utility connections for the solar system shall be installed underground on the subject property. Electrical transformers for utility interconnections may be above ground if required by the utility provider. We will be explaining exactly what we're doing there. National Grid is requiring us, and I have the impact statement that they've provided, to provide certain poles that are above ground, similar to another facility that you have here in town already. But we just want to make sure that you understand what's going there, that we have any variance that we could possibly need. Yes,
Attorney Sandra, I had a question that I had written down with regard to that. The 5.7.5K, the ordinance clearly indicates that if the utility requires it, then it's acceptable.
yes.
So with that being said, what is the reason, why do we need a variance when you as the applicant have the right to go above ground if the utility so requires?
Well, again, so it says utility connections. Yes, you're right. National Grid has issued a system impact study that we will provide to you tonight with the specific page of what they are requiring. We just want on the record that we either meet this standard or we've gotten the appropriate variance for it. I agree with you, Mr. Chairman, that we don't need it, but I think Mr. Carullo kind of suggested that we include it. So we just want, again, everything is just to make sure that we have every variance possible needed, or that even there's a statement on the record that we do meet that requirement.
Well, one of the reasons that I wanted to bring it up is that if we have a la carte menu of variances, in theory, we would have to deliberate on each variance. Because we can't, if we're going to pass one and for some reason not pass another, we can't commingle them. So we would have to then go through the procedural process of each one. I mean, we will do that if need be, or maybe it's possible that for something like 5.7.5K, that we could make a note in the motion.
Exactly.
If that was acceptable to the applicant, noting that it is compliant and you just wanted to reiterate, as opposed to going through a formal variance. So
And-
we can discuss it.
Exactly.
Yeah.
And in my 25 years of doing this, that is often what happens, is the zoning board doesn't necessarily agree that a particular applicant needs that particular variance. But it's always, from my perspective, we want to make sure that when we get back to the planning board, we have everything that we need.
Understood. And then while you're at it, if you could, when you get to, which I assume you're getting to next, 6.2 and 3.13, I mean, I think members probably saw the star that indicated that those were added, excuse me, at the suggestion of the town planner.
And I can explain.
Yeah, it seemed a bit of a stretch, but if you could
That
elaborate.
we need it.
That you needed.
Correct. I agree with you, again, out of respect for the planner, and we just want to make sure that we have everything we need. Mr. Carullo interpreted building as any structure when I was speaking with him. So, every building hereinafter erected shall be on a lot abutting an improved public street. This is not a building, obviously, but if you want to consider a building a structure, then we would request that you grant the variance. If you can make a statement in the decision that this is not a building and that we don't need that variance, we'd be happy with that as well.
So is that to say, counsel, that the planner was interpreting the solar arrays to be structures, a structure?
Yes. That's the way I understood it. That was through emails when Mr. Carullo was out for a while, but that's the way my emails are with him.
Okay. I mean, I think we can treat that, if members see fit, similar to the utility connection.
Yes.
When the time comes.
Yes. And then, again, with 3.13, no part of a yard or other open space or off-street parking or loading shall be included as a part of another yard, open space, or off-street parking or loading. Now, the way I interpret this is if you have two sites next to each other, you can't include the side yard on this lot as the side yard for this lot. I think the way I understand Mr. Carullo's interpretation, perhaps, and he actually said this one's debatable, perhaps the fact that we're using the driveway to come in is part of the yard. I don't agree respectfully, but again, out of respect for the planner and to make sure that when we get back to the planning board, we have everything we need, we included this. So I apologize for inundating you with variances that probably are not necessary, but to protect my client, I included them.
The other thing that dawned on me with that regard is that 5.7, the very ordinance that you're seeking relief from, specifically disallows having a residence on the same property. So if the point was that clearly no residence is going to be built as part of this, and therefore it could never be built after the fact. So again, it appears to be a little bit of chasing
Yeah.
one's
And
tail.
not to mention it's an easement to get to the property.
And it is,
Yeah.
yeah, it's an easement, which, though it's a legal document,
Yeah.
it's still a means of egress in and
Right.
out. So we can,
Agreed.
since we're continuing, since it's already been agreed that we will continue this application, you know, we can discuss it, and then maybe on the date of the continuance, prior to that date, if you wanted to submit verbiage that you would
Sure.
suggest, offer to the board
Yes.
to include in the motion, assuming approval, then we would entertain it, and in that way, eliminate the need for, you know, the market basket full of variances.
Thank you, Mr. Chairman. So tonight I have with me Caleb Hedrick. He is here from Nautilus Solar, which is the parent company of the applicant Islander Solar. And Caleb's going to tell you a little bit about the company and how it shares its revenue with low-income residents of the state. Jason Gold is a professional engineer. He's going to generally describe the project and address site and engineering issues. I just want to make a note that all of those ESS materials that you identified, that was the predecessor firm of TRC that, I think you could explain it better, but it acquired ESS. So all those documents were prepared by either Mr. Gold or one of his colleagues, and it's the same company.
Before you introduce them, maybe just two housekeeping, if you will. We have a special use permit and we have a dimensional variance. Now, I won't state a chapter and verse, but within the book, if those two are linked, meaning they can't stand alone, we would hear them simultaneously. But it sounds like the only variance of any substance is the 100-foot setback. So when we're ready to deliberate, that variance can be heard separate? Or because you stated in other documents that, I think it was your latest letter to the planning board, that the array could be built without the variance.
Yes,
that-
we were asked to, again, by the planning board, to move the array, and Mr. Gold can go into that.
So with
But-
that said, and for council, you can confirm, should we just make sure we agree that we would hear the variance first? We don't have to hear them simultaneously because one is not dependent upon the other?
Mr. Chairman, if I may, I mean, this is a full presentation of exactly what we're going to build. I mean, in my experience, I mean, you certainly should take separate motions, but I would ask you to hear the entire application, which includes a special use permit and several variances, because all of the testimony that you're going to hear relates to all of it, and some of it is kind of interconnected.
No, I understand. We would,
Okay.
we're not gonna, we're hearing all the
Yep.
information. It's
Okay.
when we deliberate,
Yes,
they aren't necessarily linked. So we can hear one and then the other?
You mean deliberate?
Deliberate
and
on
vote?
one and then the
Yes,
other?
you can do
Okay.
that.
Okay,
Okay.
thank you.
I just want to make sure we understood that
Yes,
we'll hear them separately. And then the only other issue before you start is the P document, one of the last ones, which was to the planning board. P7. And that was dated July 20th, and this is from this ESS group. I just wanted you to expound upon, within it, it says, quote, "This project," meaning this submission, "is distinguishable from the previous denied project on a number of important grounds." But for the record, you have not, and you didn't need to, you have not gone back to the planning board. So you would apply for a new master plan based on this document? Or since the master plan's already been approved, that's not relevant. This important distinguishable information would then be part of the next
Preliminary
review.
plan.
Okay.
So, as you know, master plan is conceptual. That was approved by virtue of your decision in the appeal. But having said that, we took the comments of the planning board during the master plan application review, and Mr. Gold did make changes that we hope that they will be more satisfied with. So,
Exactly, that's
yeah.
why I noted that.
So he'll be
because
going over that
It was
as
clear
well.
that you had done that as
Yes.
part of that document, so,
Yep.
okay, thank you.
Okay, so first, I would just ask Mr. Hedrick to come up and talk about Nautilus. I'm just gonna sit.
Good evening, everybody. My name's Caleb
Yeah.
Hedrick.
If you could, we
Yeah.
don't have a stenographer, right, because can you just raise your hand? I'll just ask him to, did Tiffany, you want to do it? Well, I can do it unless you want to do it. That's fine. Can you just raise your right hand, state your name slowly so that we can record it and indicate that your testimony will be truthful to the best of your knowledge?
My name's Caleb Hedrick. I'm an assistant project manager with Nautilus Solar. Good evening, everyone.
I'll just indicate that your testimony will be truthful to the best of your,
And my testimony will be truthful to the best of my knowledge. Thank you, guys. My public speaking is a little limited, so pardon me if I falter a little bit along the way. But I wanted to talk about Nautilus and, quite frankly, why I'm proud to work with Nautilus. I predominantly work on the construction side, so I'm normally speaking with contractors. This is a little different environment for me. When we're building community solar projects, and what's awesome about that is we're establishing relationships within these communities and establishing community solar programs, and essentially our energy off-takers are neighbors around that site where we build. What's really unique about this project here in North Smithfield is it's part of a energy portfolio with a couple sites that we're developing in Exeter. And we've created a partnership, Nautilus has created a partnership with the Public Housing Association of Rhode Island. They have selected various housing authorities throughout the state that are going to benefit from this energy portfolio. Through this program, Nautilus is able to offer clean, safe solar electricity to these housing facilities through a virtual net metering program available through the state and administered by InGrid. When the system produces energy, those housing authorities are going to receive bill credits, which is going to show up as a negative value line item on their electrical bills. The amount of those bill credits they receive is going to be proportional to the amount of the solar energy facility to which those organizations are subscribed. Through those agreements, the housing authority receives those bill credits at a substantial discount. There aren't any upfront costs, there's no fees or minimum payments associated with the agreement. The Public Housing Associations of Rhode Island only pay when the solar facility is actually generating electricity. And therefore, the participation is an opportunity for long-term guaranteed savings through these virtual net metering credits. The contract terms with these agreements to those housing authorities are established for 20 years. They'll receive a discount for 20 years. And just within 1 year of operation, this energy portfolio is estimated to save Public Housing Association and those housing authorities throughout the state, just within 1 year, up to $1.8 million. Over the next 20 years, the savings are anticipated to be around $39 million. This is including North Smithfield and some projects we have in Exeter as well. Not to mention, this is going to factor in the small degradation that happens in the solar panels over the course of their lifetime, and a modest bill credit rate increase of 1% over the 20 years. Through this process and through these agreements we've established, Rhode Island Public Utilities Commission had to approve the conglomeration of all these housing authorities operating with this program, and that approval occurred in the spring of 2021, and the Department of Housing and Urban Development also had to approve this agreement with those housing authorities, which occurred in August of 2021. Thank you.
Thank you. Any questions for the presenter? Thank you.
So at this point, I'd like Mr. Gold to go through the plans with you, and then we'll talk about the specific variances and the standards for the special use permit after he presents.
Yep. Sir, if we can do the same thing we did with the other applicant, presenter, please.
You have to remind me what to say.
Just to give your name and indicate that your testimony will be truthful to the best of your ability and
My name is
knowledge.
Jason Gold, and my testimony will be truthful to the best of my knowledge.
Mr. Chairman, before Mr. Gold starts, I'd like to request that he be considered an expert in the area of site engineering. I can go through his credentials with you. I don't think he actually appeared before this board, but may I, Mr. Chairman?
Sure.
What is your license, Jason?
I'm a civil engineer, licensed in Rhode Island
Okay, and for how long?
for 25 years.
And you've worked on solar developments in the past?
Yes.
And have you appeared before boards to present?
Oh, yes.
I'd like, just estimate how many boards in Rhode Island you've appeared before.
Many boards in Rhode Island.
Okay. Courts, any courts?
No.
Okay. Mr. Chairman, with that, I'd ask that you accept him as an expert in the area of site engineering.
Are you a PE or?
Yes.
Okay. In the state of Rhode Island?
Yes.
Okay. Well, to the extent that you're a licensed professional engineer, then, yeah.
Thank you. So a little background on just the existing conditions, and then I'll go through the.
Do you have them electronically?
Yep.
Okay.
I'll get those plans up there. So I'll describe the existing conditions of. The June, that's the one. Yep. Yep. Thank you. I'll describe the existing conditions of the site a little bit, what we're proposing, and then I'll go through the zoning ordinance and how those are met specifically. So the lot, if you can go to, let's see, page 4 is SO1. It's a nice overview. Yeah, that's good, thanks. So there's 2 lots, as was described. The front lot is the lot that will provide access, but the lot that the development's on is all on that rear lot, lot 19, AP 16, lot 19. It's a 22-acre vacant wooded lot. It doesn't have any frontage, as was mentioned. It's zoned rural agricultural. The surrounding lots are primarily wooded. The residences are on Iron Mine Hill Road, are greater than 400 feet away from the project, except, of course, for Lot 18, which we're accessing the site through. It's undulating topography, generally slopes in southeasterly and southwesterly directions. It's generally less than an 8% slope in the area where most of the work is proposed. The slope gets steeper to greater than 8 or 15% on the southern part of the property. The southern part of the property also has some really large areas of boulder coverage, really just big boulders. So that's part of the reason why that area is off limits for development. There's also some wetlands to the southwest, which are shown in the bottom left corner there. The western portion is located within a natural heritage area, and I'll get into that in a minute. It's not in a wellhead protection area or an aquifer protection overlay district. There's no prime farmland soils on site, and it is within a surface water protection area.
If you could, Mr. Gold, the top left corner,
Yes.
where the array, if I remember when I marked up my version, the setback line, is that where the encroachment is proposed?
The top.
The top left corner?
Well, it's the top row.
Yeah.
Right.
Because I saw at some point the hash mark that indicated setback line cuts through the panels
Yeah.
as
so-
it moves from,
Right here.
at
Yeah,
that
so
angle.
this dash line is the
Yeah.
100-foot setback, and then it cuts across these panels.
And the
You go like the
topography
second-
there,
the
the
second.
topography there is high to low, low
Yes,
being the
yeah, it
panels?
slopes down to the bottom.
So the top of the
So-
drawing is higher in elevation
Yes.
than the panels?
Yes.
Okay. And the logic of the planning board was that the setback wasn't relevant because of the topography?
So, yeah, I can jump to that now if you want. Let's see, if you can go to page 7, I guess. That's almost there. Actually, that doesn't have the topography. Can you go a couple more sheets? Yeah, that one's good. And just zoom out a little bit. So the shaded areas are slopes that are steeper than 8%. The darker colors are steeper than 15%. It's kind of hard to tell on the screen. So all the shaded areas are steeper than 8 or 15%. So the array, one of the original concepts, we had it further down to be outside that 100-foot setback from the north. But then that puts you into all these steep slopes. So really, I mean, it was a suggestion of the planning board, but it's a good suggestion, was to push it, north where the area is flat. That encroaches in that 100-foot setback. It's encroaching in the 100-foot setback, but of course, that's a setback from the property that's also a participant in the project.
So
Right.
even though it's a interior lot line, if you will?
Essentially, yeah.
Yeah.
I mean, functionally, I guess, if you want to call it that, right?
And what will occur on the lot to the north other than egress, in and out, egress and access?
That's all, I mean, that's an existing residence. So the entrance is off of the existing driveway.
And how far is the residence from this location?
That is, yeah, so if you can go back, you're going to get a lot of exercise today, Carl. Yeah, go back to 7. No, I'm sorry, 4. There we go. Yeah, so the residence is about 200 feet. You can see it in the middle of the clearing up there. So that's the existing
And
residence.
the grade differential there is significant?
Not so much between that house and the solar array. It's the south of the solar array.
Okay. So when we're talking about buffering, going back to the planning board, is that elevation that would be buffered? That you were
Yeah,
gonna
so the
provide
landscape-
additional plantings?
Additional plantings will be planted along the northern property line.
And that's the fence line that we see there? Or the fence line would be right next to the array?
The fence is next to the array. right?
Okay. Okay, thank you.
So it's a 2.8 megawatt DC ground mounted array. We talked about the axis already. The array itself, the panels, they cover about 5.5 acres. The fence surrounding the array covers 6 acres, which is 27% of the lot. And the limits of disturbance, which is the fence and includes the shade tree clearing and the detention basins and the road, as 13.3 acres. The yard setbacks are met. There's no front yard setback. The side setbacks are 25 feet, and we're providing 84 feet minimum. The rear setback is 40 feet. We're providing 275 feet minimum. We talked about, so we were talking about the 100-foot setback. So the 100-foot setback is met from all other sides except for that north side.
So is this property landlocked without the
Yes.
easement?
Yes. So if you can go now, if you want to go back to back to 7. Yeah. Thanks. This is easier to see view. So there's a 50-foot vegetated buffer of existing woods that we're proposing. So you can see that that hatched area along the side. That's existing woods, which is 50 feet pretty much the whole way. There's a couple areas you can see next to the detention basins where it gets a little thinner than 50 feet, just to provide the clearing needed for those detention basins. But other than that, 50 feet. And then in addition, because we're pushing this to the north and based on feedback from the planning board, we're also proposing some landscape screening along that northern area. And then you can see on the northeastern corner, it kind of comes around the corner a little bit. So that's the landscaping area, which is screening the site from the residents on Iron Mine Hill Road. The other area that Kelly referred to earlier, that where no landscaping is proposed, is along the eastern and the western side and along the south. There's no residences over there. That's just all woods. So taking out trees to plant landscaping to screen it from nobody doesn't really make any sense. The stormwater management is proposed. There's three basins and a dry swell. The final pole design, that's determined by National Grid or by Rhode Island Energy, so they decide where their poles need to go. What we're showing here is based on their initial feedback. All the electrical within the array will be underground, and then it becomes above ground once we get to that first pole. We're currently showing 13 poles. 6 of them are on lot 19, which is this site, and then 7 on lot 18, and that's really just to get them to the street. And again, that numbers will be determined by Rhode Island Energy once they finish their design. So to go through the zoning ordinance, section 5.7.5, I'm not going to read them verbatim, but just to paraphrase the requirements and how they're met. 575A requires a special use permit, which of course is why we're here. And no system permitted within 250 feet of a historic site or structure. No historic sites or structures were identified within 250 feet. B, the parcel must be a minimum 6 acres in size and vacant, which it is. The parcel's 22.2 acres and vacant. And the proposed solar array inside the fenced area must not exceed 30% or 6 acres, whichever is less. The fence is 6 acres, which is 27% of the lot area. C, a lot may be subdivided to create a vacant parcel. That's not applicable. We don't need to do that. D are setbacks. 1, all solar arrays must be set back a minimum of 100 feet from property lines, which we've discussed. 2, water bodies and wetland setbacks must comply with state environmental regulations. The limits of disturbance is well outside the 50-foot perimeter wetland. And of course, that's going to go through DM permitting as well. And it's been submitted. They're reviewing it now. E, no impacts from solar reflection or noise generation on neighboring properties. So regarding the reflection, there's a document published by Mass Department of Energy Resources, DEP, and Clean Energy Center in June 2015, which is titled Clean Energy Results, Questions and Answers, Ground-Mounted Photovoltaic Systems. And that states that solar module glass is less reflectivity than water or window glass, And reflected light from solar panels will have a significantly lower intensity than glare from direct sunlight. So no impacts from solar reflection are anticipated. And then I can also add to that, all the residents are to the north, so essentially behind the array. So glare is not really a concern. Noise, we provided a noise impact study, which was completed on January 7th, 2022. The noise impact study found a maximum sound level of 38 decibels. That's A-weighted average at the property line. And that's less than what you typically have as the ambient daytime noise level of 40 decibels. And it's also less than the 53 decibels, which is allowed in a residential area by the noise ordinance. Moving on to F. System and fencing shall not have an unreasonable adverse effect on fauna or rare, threatened, or endangered wildlife habitat or plants, and rare and exemplary plant communities. We prepared an environmental impact assessment in January 7th, 2022. In summary, that found no significant impact to wildlife, fauna, access, or migratory patterns. Wildlife can travel around the fenced area. Our small wildlife can travel underneath the fence. There's a 6-inch gap provided beneath the fence for small wildlife migration. A small, about 1.4 acre portion of the project is within the natural heritage area boundary. We checked with DEM, and that boundary is associated with 4 plant species of state concern, which were identified a mile west of the site. So the way they make these boundaries is when something's spotted, they put a big boundary around it. It doesn't necessarily mean that it's found there. It's just kind of a flag. So the 4 plant species of concern are grass-leaved arrowhead, woodland sunflower, wood lily, and drumhead's milkworts. So the grass-leaved arrowhead and the drumhead's milkwort, they're wetland plants. We're not doing any work in the wetlands, so there won't be any impact there. And the woodland sunflower and the wood lily habitats, and the wood lily, their habitats are not present on site, so they don't grow in the conditions that the site is, so no impacts to those species are anticipated. G, a permanent all-season green buffer shall be planted within the 100-foot setback, and we've discussed that. H, a 6 to 10 foot tall security fence is required. We're proposing a 7-foot tall chain link security fence. I requires clearly visible warning signs along the security fence identifying the owner. And if you want to go to page 12, we have details of those are provided. In the middle of the page there, those are the warning signs. J requires a maximum height no more than 15 feet. And on the top left is the detail, which shows a maximum height of 15 feet for those panels. K is related to the utility connections and must be underground except for required by the utility, and that's been discussed, so it's underground within the array. The utility is requiring it above ground for the pole-mounted equipment. L states that the appurtenant structure shall be within the security fencing and shielded by view. That was shown, I won't make you go to that page again, but that was shown on page 7. The equipment pad is within the fence, and it's also behind that vegetated buffer. L also says storage buildings should not be permitted, and no storage buildings are proposed. Lastly, M, to the maximum extent practical, installation shall preserve the natural features of the site, avoid areas of environmental sensitivity, and minimize negative impacts to natural features, historic and cultural resources, and scenic areas. Any grading or site preparation must, to the extent possible, conform to the natural topography of the area. Excavation of materials prohibited unless it is necessary and shall only be that which is minimally necessary. This kind of ties to that variance request for that 100-foot buffer, because this requires us to try to work with the existing topography, right? And in order to work with the existing topography, we're pushing it north to that flat area rather than being in the steep area, which would then require excessive grading. And this asks us to do it to the minimal amount necessary, which we're doing. So we're also avoiding the wetlands. There's no historic or cultural resources or scenic areas were identified on site. Excavation is minimal. Most of the excavation is just for those stormwater detention basins that were proposed. And that,
If you
yes.
could, Mr. Gould, could you, what was the, what's the subsection that we were continuing? Is that G?
G,
The visual buffer and setback?
yes.
Can you just elaborate briefly on, is that where you made the comment about the southerly sections and the fact that it's not exposed to anything and whether or not you needed an exemption from that? So-
Right, yeah, so, yeah, no, this is good. Yeah, so we're leaving existing woods for 50 feet, a 50-foot width around the whole property, right? And we're planting landscaping along the north, which is closest to the abutting residences. But the way this ordinance is written, we would have to plant landscaping all around the site, even though it's all wooded around the property, right? So that's what that refers to, right?
So short of an exemption noted in subsection G, whereby, existing vegetation or existing forests exempts, it's not
Right.
there,
It
so your
doesn't say
concern
that.
is that the planning board would flag it and say, well, you need a variance?
Right,
Okay.
right. And it doesn't, and it's not worded to say, I think it's worded to say from neighboring properties or something,
Yeah, fencing.
not from like neighboring residences or, so even though, to the south, it's owned by, the property to the south is owned by, the city, yeah. So it's, I think they're preserving that for the aquifer, so.
Yeah, it says neighboring properties, it
Right,
doesn't say
so
residences.
provide landscaping for that property is,
Okay, so
obviously it doesn't make any sense, but that's how it's written.
we understand that that's the essence of what you would come back with and put it in a formal document.
Exactly,
Okay. And while you're there, the property to the north,
yes.
that is where the residence is that the planning board took issue with in their
Well, there's two, yeah, so
denial?
there's the lot right to the north, and that's, AUTHIER, they're like, they're an I don't know if they're an applicant, they're a participant in the project,
Well,
right?
that's what I mean.
Yeah, but then
That's-
there's also one,
Yeah.
to the right, to the east of them, and a butter who also had a concern, so, and that's why it wraps around the corner over there, is for that a butter as well.
But the main egress access is through the easement granted by the property owner to the north.
Yes,
Which is the only means by which you can get to
Right.
the closest street.
yes.
Is the array in any way, shape, or form visible from either of those two residences that you referenced?
Well, it won't be with the landscaping,
Yeah, not to mention,
Right.
it's tilted to the south. It's not tilted to the north, right?
right, yeah.
Those arrays are facing
South.
south on the
Without,
drawing.
without the landscaping, lot 18, the lot that we're accessing the site through, the array would be visible.
Okay.
So that's why the landscaping is proposed.
You had said it was, the arrays will be 15 feet off the ground?
At the highest
At the
point.
That's
highest,
maximum height.
at the
So
highest, right.
All the foliage you're gonna plant and everything will be higher than 15 feet?
It will grow to that height, yeah.
Okay.
Well, again, we should note that compliance with the ordinance is not our jurisdiction. That falls under the permitting process and the planning board review. As long as you comply with what's written in the ordinance, we have no involvement. Even though it is a zoning ordinance, you only come to us for relief. But the point is that sometimes that has been discussed, that is it mature vegetation, is it, young vegetation? But I would think that you're gonna bounce that back and forth with the planning board.
Well, it states it in the ordinance anyways.
The,
Sure.
And it does indicate, because we had addressed that, I think, when we were writing the ordinance, then the ordinance committee, so.
The
trying to
relief on
cover
the,
all that.
the relief on the 100-foot minimum that you're seeking, that's so that you could build a 2.8 megawatt facility.
Right.
If you didn't have that 100 feet, how many megawatts would you be able to produce? Did you look at that? Would it be 2.4, 2.6? Is that viable or feasible?
Yeah.
Did you even look at that, or?
Just push it south.
Well, we could, right, I mean, we could push it south, right?
there's a
But
few
then, but then
options.
we could push it south and maintain that same output. But this is a better layout, right? Because then now we're working on those steep slopes.
Would there be, if you moved it to the south,
Right.
you wouldn't know if you had to do any blasting because of the ledge there, correct? So that's why the planning board had you move it to the north, so you wouldn't have to do a lot of excavating?
There might be some grading that's needed. We wouldn't do blasting, but there might be some additional grading there. There'd be more erosion control concerns, just because you're working on a steep slope is more difficult. And there's a lot of boulders there as well. So it's just less earthwork.
Well, to clarify, one quick question, to clarify, how much, what's the encroachment?
Yeah, it's also
What's the encroachment? Is it 10 feet, is it 20 feet?
Oh, did I skip over that? Yeah, so it's about 60 feet from the property line now. So
So it's
we're
a
about 40
40-foot
feet within
40-foot
40-foot encroachment.
Of relief?
Right,
And it looks
Right.
like it kind of gets wider on one end and shorter on the other
Yeah,
end. So
right.
60 foot's on the right side, and then you
Right.
got probably 70 or 80 on the left.
right,
Oh, meaning the relief lessens?
Right.
Yeah,
Yeah, the
'cause it's-
encroachment lessens,
so
okay.
closest is 60.
Okay. And again, you made it clear that this was put upon you in a friendly way by the planning board as an attempt to, and, we should note that when it comes to civil-type issues, that is supposed to be the planning board's expertise. So I have a tendency to defer to them if they gave you their candid opinion, and their job is to protect and preserve in many ways. So I think it sounds like it was a reasonable, and because you're meeting that initial concern from the denial, which was the additional barrier to the properties to the top of that drawing. So, okay, interesting. Any other questions for the presenter?
Yeah, I have a question on sound. What kind of a sound does it make? A humming sound?
I would describe it as humming sound, yeah, if you're close to it.
Like white noise?
It's a transformer, right? So if you're next to a transformer, it's that kind of. But if you're close to it, right? And so the noise study found that at the property line, it's
Right.
less than ambient.
Right.
And it drops. If you've either been near a solar array or just even like any big transformer at a commercial site, right? It drops logarithmically, which means, you take a few steps back and it drops quite a bit, so.
Plus you're doing, evergreen planting there too, which
And
is
there's-
gonna
and there's
decrease
plantings
it even
there,
more.
right.
If you're getting zero drop at it now, it's gonna be even less than that once you put the planting in, so.
Right, yeah, no, that's a good point, yeah. And the noise study doesn't include the woods, it's very conservative, so it doesn't take into account any vegetation.
Okay, are there any other questions?
You have more? You have more, right?
Okay, do you have anything further to present in that regard?
Nope.
Okay, thank you.
I'd just like to submit, as Jason spoke about the,
On a special use.
what did I do with it? Might be another. Huh? I don't know how that didn't make it, 'cause it's right here. I have too much. Mr. Chairman, may I approach?
Yes, please.
So, what I did was, I'm gonna give the chair a full copy of the system impact study, but then on page 5, it specifically talks about the system modifications, and this is a National Grid document. So they basically approve what is required.
So we should note this, Tiffany, what was our last, was it P10?
10, yeah.
So this is P11? P12? Because we added that,
Oh,
Yes, this would be P12.
P12.
And, Mr. Chairman, I just want to add also, when you considered our appeal, it was specifically about the appeal, or the planning board's decision, was specifically about consistency with the comprehensive plan. And in that regard, town planner Mark Carullo submitted a recommendation to the planning board and opined that the proposal is generally consistent with the town's comprehensive plan. Additionally, land use expert and certified planner Edward Pimentel submitted a substantial report supporting the approval of the project. And we submitted that report to you with our appeal. Mr. Pimentel was unavailable for tonight's meeting, but I'd like to just resubmit his report for the record that you've already seen in the appeal.
That's fine, yep. So this will be P13. And again, all of this, we were presented as part of the appeal package.
And lastly, Mr. Chairman, if I may, I just want to go through the standards for the special use permit. I think Mr. Gold touched on all of them, but they're separate from the ones in 5.75. Hold on. So this is just for, like, any special use permit. Ingress and egress to the property and proposed structures thereon, with particular reference to fire or catastrophe. We're providing access, as Mr. Gold described. Off-street parking and loading areas where required, with particular attention to ingress and egress above, and the economic noise, glare, or odor effects of the special use permit on adjoining properties. Again, general special use standards. Mr. Gold went over the noise study as well as the glare issue with the solar reflection, so you heard from him on that. You're also to consider refuse and service areas, which there are none. Utilities with reference to locations, availability, and compatibility, similar to that section K that we're talking about with regard to the variance. Screening and buffering with reference to type, dimensions, and character. Mr. Gold went over the buffering with the landscaping. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility and harmony with properties in the district. Mr. Gold talked about the signs. There's no lighting for this project. He talked about glare. And as we've talked about, we talked about this during the appeal, this use is a conditionally permitted use. So the town council has already determined that this is an appropriate use if we meet all of these conditions. Required yards and other open space, we've gone over that, including the setback issue and general compatibility with adjacent properties and other properties in the district. So we feel that we meet all of those standards, which again are just the general standards for a special use permit. And I think that's it for our presentation. As we discussed originally, after public comment, we would like to continue the matter so that we can properly notice for that section G out of an abundance of caution. And I think that's it, unless you have any questions for any of us.
No, I think we're good at this point. Any questions, members? Hearing none, we'll continue. We're not going to close your section. Are there any members of the public that have any comments with regard to this application? Please come forward.
I make a motion to open public comment.
Yeah,
Second?
second.
There you go.
We're opening public comment now. Thank you. If you could, for the secretary, just indicate your name and address.
My name is Donald Croto. The address is 752 Iron Mine Hill Road. I'm a butter to the property. I actually abut it by 800 feet, and I will be able to see it from my house, even though they say the house is up there. This property actually goes this way. I can see his house, which is up there from my property. It's not in the fall, when the trees are, excuse me, when all the leaves have fallen, I can actually see his house, my backyard. So again, and I have it noted here from the plan, when we met with the planning board, if they get the variance, not to have to follow the minimum requirements of 100 feet from the property, that means that the, excuse me, got the wrong one, sorry. It was mentioned at the planning board meeting that they may require to put trees along the property lines to hide the solar farm from abutters, and that's from when they were on my property. That was brought up at the planning board meeting.
What is your specific issue the variance request, or is your specific issue visual? What's your specific issue?
Mostly visual.
And is that with or without the additional buffering that the applicant is presenting? We have two things that, you need to be aware of. One is the actual written ordinance, which they're compelled by law to abide by. And if you need it, we can have somebody email it to you. You can go online and print it, which shows all of the requirements as to buffering, which you heard us speaking about a little bit. Then you also have the planning board's comments when they denied it, that they wanted that residential property buffered. And then the applicant came back with a letter indicating that they were going to do that. So I guess the question really is it the issue of the solar panels, or is it the concern that you don't want to be able to see them?
Well, basically, I don't want to see them.
Okay. And have you discussed, I'm just curious, have you approached the applicant or their engineer to have him prove to you whether you will or will not see them?
Well, again, I can see, from my house, I can see the house there, and I can see in the woods here. And plus, we're in these, families in these woods all the time. We have trails that run around the entire property, all along that whole side, and really don't want to be looking at huge solar farm along my 800-foot, my property that abuts it.
Yeah, but again, if you, I think if you can discuss with the applicant's engineers what they have to do to comply with the ordinance and what they're willing to do for your specific issue, that might go a long way. We're happy to hear your issue, but we also have to be fair to all parties and make sure that something constructive occurs here. If there's a solution, then it's in everybody's interest to find the solution. They have a right to do certain things with the property, no matter who owns it and what they want to do with it. The solar is allowed with a special use permit. And the conditions of that special use permit are in this document, and they were written to protect abutters. I served on this committee when it was written, and our primary objective was to make sure that abutting properties did not have to stare at solar panels. So I think if there is an issue, we can entertain your thoughts, but it would be good if maybe between now and when you understand we're going to continue this meeting, we're not going to vote on it tonight.
Correct.
So what might be helpful for you and for us and for the applicant is if you can make contact with the engineer and work through the planning board, so if you want a third opinion that's impartial, to ensure that they are doing as much as they can to comply with the ordinance, and/or if they have to do a little bit more because of your special condition, then maybe they can do that. So at least we're able to try to get you everything you need to be compliant with the with the ordinance, but also to, provide for your quality of life.
Mr. Chairman, maybe you want to go to the plan page that shows the house up in the front, and he can better describe, so everybody could understand that.
That would be a good idea. Carl, do you know what page that is?
7?
Page 4? So we can zoom in.
I mean, it's a good distance. Excuse me,
Mr. Gold, maybe you could go up there with him, or?
It's a good distance away, but I have a large open area.
But you're uphill of that?
Right.
So that's progressively down, so
Yeah.
if there is planting, and maybe they can come up, could you possibly go up there with this gentleman and show him, and for the public and everyone else who's present, what the grading looks like and what his line of sight would be with what you're proposing?
Yeah, so first, I appreciate your suggestion that we work together. So we actually met on site with the planning board, and he was there. So and this is why we're proposing that landscaping along. Originally, we weren't going to do any landscaping. We're just doing the 50-foot buffer. But based on the site visit and conversations that we had, and we went to the site and we had it marked out. So we stood there and we looked to see where his house was. So we did this. We've done this visual analysis, and that's why. This proposed landscaping, wraps around the corner like this, right? Because this house is up there. So this arrow, I can't read that. It's 400. I can look it up. It's 400 something feet to his house. So that's what this landscaping is for. And there's also privacy slats along the fence as well. So that's what we're looking at. So that house is actually, it's not on here, but it's up on that.
And the grading differential is approximately 100 feet, 50 feet in differential, or?
I don't know off the top of my head. It's been a while since I've looked
But
at the
a guesstimate, it's a slope.
topography.
It's a slope.
Yeah, I mean, I believe it. I believe it does slope down, yeah.
Okay, and were you able to meet with the planner so that you can get an impartial, all due respect to the applicant? I know, your tendency might be to think that they're just going to tell you what you want to hear, but have you met with the town planner to get his verification of what the applicant plans to do?
Not really, no.
Can I suggest that, because you have the opportunity to come back here for the continuation, it might be beneficial to meet with the planner after the applicant's engineer, and just to let him try to show you, if it's to your satisfaction and they're making their best effort, that the buffer will or will not work. And so we can find a common ground if there is one to be found. But your concerns are received by everyone, I'm sure, and we're appreciative of it. And we want to try to make sure that both parties can be satisfied here, that they can go forward with their project in compliance with the law, and that maybe take a little extra effort, which they appear to try to be doing, to satisfy both yourself and the other abutter. So is that possible that you could meet with the town planner, who will be impartial?
Sure.
Okay, I think, and then if your applicant,
Happy to take
And I
his
can-
phone number.
And I can add, right, we're an master plan, or special use plan now, so we still have the preliminary plan submission.
Yep.
Right, so this is just showing we're gonna do landscaping. The preliminary plan will have the landscape plans, right? And that's when the planning board's gonna ask us to show, know, the line of sight, what the topography is, and how that works, and make sure the landscaping's tall enough. So that, you know, that.
We're taking, yeah.
We haven't got there yet.
We're
So-
taking an extra step.
Right.
All we can do is grant or deny the request for the permit or the variance. They still need to go through all of the hoops and to jump over all of the ropes for DEM, environmental, and 2 more tiers of planning board. And so you've got multiple opportunities to ensure that the best that can be done to protect your rights, it will be done. But this is our way of just reaching out a little bit faster to see if you can't do something ahead of the game, because it's always nicer if we can have harmony than otherwise. So if you don't mind, I think that would be the best thing to do. The applicant can get your phone number, and you can meet with them and the planner on your own so that you get an impartial opinion. And then you're free to come back to our next meeting when we continue it, so.
There was one other question.
Go ahead.
That I brought up twice.
Sure.
And asked if the city of Woonsocket was ever notified, since they are a butter.
We can check and see if they're on the list.
I saw Woonsocket.
Yeah, I thought I did too. The abutters list is here if you'd like to see it, sir. Yeah, they're here somewhere, I see
Yeah, I
it.
saw them right here, City of Woonsocket.
Yeah, City of Woonsocket.
Okay, because again, I never got an answer, a direct answer when I asked during
Why?
planning board meetings.
Okay. Well, I can tell you with certainty that this document was submitted to us, and it indicates that City of Woonsocket was notified of this meeting. They're not required to notify them of anything else other than the fact that this meeting will be held. I don't know that the city has ever attended any meeting where they've been notified, but they met the standard that they're responsible to
Because I
meet.
did talk to one of my friends who works on the waterworks department and he had no knowledge, because they have purchased all those properties.
Yep.
All the abutting property, to ensure that we'd get no contamination, because there is a brook that runs all through there, all the way to the reservoir. So I know they did have concerns about that.
Well, you're happy to take a picture with your phone, and you can ask your friend the address that it was sent to is right here. So feel free.
From that list, it's automatic labels, so it's not somebody transposing any numbers, so.
So I'm just wondering if it got to get to the right department. That's the only.
Okay. Thank you, sir.
Thank you.
Anyone else from the public for this application? Okay. Vinnie, you had an additional, hold on, wait, additional question for the applicant?
Yeah,
Okay, who do you want to talk to, the engineer or the lawyer?
I would assume.
Well, she can
This
get up
young
to
lady right here.
the podium, please.
When I was reading the documents, it said that they were going to show us that the properties wouldn't be devalued. Can you show me that tonight?
Well, this is a solar installation that isn't going to be seen from any other property. So I don't know how the solar installation would devalue other properties.
Well, are you familiar with the study, solar studies on farm? Solar farms reduce home values up to half a mile.
I'm not familiar with that. I don't know what you're reading from. I don't think that's necessarily the case. And I think that you can use your own knowledge about the fact that this is secluded, and no one's going to know about it except, I mean, I know Mr. Croto does, and I acknowledge that. But other than him and Mr. Authier, no one will ever see it. So I don't think a buyer would even have knowledge of it in terms of what they would offer for a property.
Well, what they do, and I haven't, it's happened to me already, and it happened up in the other property up off my road. When we buy something, we look at aerial views, what's around us, and we had some nice property that we were going to buy, and once my partner just looked at the aerial view, he said, look, that big solar farm, and then there's a study out, and he gave me copies.
We can't, you have to be very careful. We cannot introduce information. We can only go
this-
by what the applicant has
Well,
submitted.
The applicant, I'm not introducing
Now, you can ask
anything.
her a question, but you can't
The
introduce
applicant said that
anything
this would
else.
not reduce property values. That's documented in the information I got, in the packet I got.
Yeah, but
And
you
I'm
cannot,
just
you
questioning-
can't reference something that is outside of what was presented. You can argue it, but you can't introduce any
I'm
other
not introducing,
literature.
I'm just telling you, there's studies. You know, in other words, when somebody says something, I'm supposed to just believe it because they say it? And I have something right in front of me
Well,
that says it reduces home values. I was just asking her that
Well, you
question.
can
I
ask her to, you can ask her how she comes up with that
And-
statement,
well,
but
first of
short
all,
of that.
respectfully, none of us are experts regarding the values of property. You're not, I'm not, right? So we're reading things that I don't know where it even came from. Secondly, we went through all of the standards for the special use permit, and I know what they are for variances. And again, the effect on neighboring properties is a standard, but I did not read that devaluation of nearby properties is one of the standards that we have to meet. And again, I mean, I acknowledge that we don't want to devalue surrounding properties, but I just want to be clear that that is not one of the standards. We just went through all of them, and I don't, it just wasn't one. And again, this is a hidden property. So if one or two people look at a satellite view when they're, I mean, that's not my experience. People go to houses and they look at them and they decide if they like them. You know, that's not my experience. But as I said, neither one of us are an expert in real estate appraisals,
No, that's
so I'm
why
not sure that that's appropriate.
I was just picking up on, it was in your report, that doesn't devaluate property.
Yeah.
Yeah, but
just asking how they came to
Vinny, I think you can argue whether that's.
I'm not arguing, no. just
No,
a
I'm
matter
saying
of
you
fact.
can make an observation of whether that comment or statement is true or false, but we have to rule on the 8 items that are listed, and devaluation of the market or the property is not part of the 8
It
criteria.
doesn't say devaluation, but it says right here in some of the standards, the neighborhood conditions are an important factor. If the area in which the proposed use should be.
No, hold on, Vinny, that's,
What document is Mr. Marcantoni
yeah, we,
referring to?
that's not, it's really not relevant. We have to stay in the center of the road here. The only criteria that we can rule on is on page 9.2 of our manual, and it's items 1, 2, 3, 4, 5, 6, 7, and 8.
Right.
That is it, and I don't want to get,
I think we have right here. It says general compatibility with.
well,
the
no, it has to be this, right here. That's all we,
This is a copy of it.
no, this is right here. There's
This
only
is
8
nine-
items.
This is section 9.
9 point,
9-28.
but it only results to
No,
special
Smithfield
permit.
zoning ordinance.
No, it's not the ordinance, it's the special use criteria. That's all we can rule on. Economic value is not listed there.
I'm-
So
And-
we
and
have
again-
to,
I'm
it
not
says,
talking about economic values, no, we already talked about that. And I'm just showing you how they coordinate general compatibility with adjacent properties and other properties in the district.
yeah, but the general
Compatible-
compatibility is not economic value. That's what you were arguing.
And just to be clear, general compatibility was addressed in the planner's report that we presented. You know, and by the way, the town council, by ordinance, has already established that solar facilities are compatible. They're necessarily compatible because they are a conditionally permitted use in your zoning ordinance. And if we meet all of the standards that we just went over, both in the special use permit category and the performance standards that Mr. Gold went over, then we're, you know, frankly entitled to a special use permit.
I think we should just continue this
Yeah, that-
conversation. We're
another
meeting.
time. I just picked up one thing, I got a lot more in that area.
Well, we're meeting again, so we can go over it, but we have to stay within the boundaries of those 8 items. Yes, every one of them has a little bit of subjectivity to them, otherwise robots could do what we're doing. But within that subjectivity is the relevance of what we operate with on virtually every application for relief that we get. Some of them are glaring in one respect, and others are glaring in their ambiguity, and we have to find our common ground. So let's continue this. until the continuation of the meeting. If I hear that we had no other public comment, we're going to leave that open as well in the event that when we come back. So can we have a motion? We want to continue this to a date certain. Larry, do we have what's the next date certain? And the timing isn't relevant to the applicant, right? It's a fairly straightforward affair
Yes.
as to rescheduling?
Yes.
We have 3 cases that we have to hear on the 10th of January already.
Okay.
So the next one would be the second, or the 4th Tuesday, I believe it's the 24th, does that make sense?
Yeah, we'll double check. That's 24?
24.
Okay.
No.
No.
We don't usually meet during that week.
What day is that?
Mr. Chairman, one more thing, if I may.
Yep.
January 10th, January.
So I believe Mr. Marcantonio was referencing our application.
Right.
So apparently, the application does have a question, does it significantly devalue? But that's an error in the application. That is not one of the standards. It's probably an old application that, you know, so I just want to be clear, because that's where he's getting, I was confused at where he was getting it from, because Mr. Pimentel doesn't have the expertise to opine on value.
Yeah, the application, I think the town,
It was from
we
your
need to,
document.
we need to review the
Yeah, it
application.
was from your document.
Right, but it's actually your document.
Yeah,
My
it's,
document, okay.
all right, let's go.
Document I got anyway.
I just want to be clear.
No, but you're correct. Our documents are not always precise.
Everywhere else.
Yeah.
It's not just.
And the only thing that we're compelled by law to abide by are these 8 items, and that's what we're going to do. So, do we have a motion to continue to a date certain of 1/24/23, this application?
I'll make the motion to move the application to a date certain of January 24th.
I'll second it.
Second, we have a second, all in favor?
Aye.
Aye, and that's 7 o'clock, yep. Okay. Yes.
Mr. Chairman, I guess I want to make one other point that the board should be aware of and the applicant should be aware of. As of this month, the zoning board needs 4 votes to make a positive approval. As of next month, it's 3 out of 5. I think since we started this application this year, we have to talk about that, and
There's a lot of debate over.
how that's going to shake out. So depending on, it's something for the board to think about, because we may want to just be very careful and not automatically create a case that has to be dealt with if we can avoid it.
Well, is there any precedent on previous rules where the applicant was vested, therefore you follow the rules that were in existence when the application was received?
Well, and that's why I'm mentioning to the applicant. I think the applicant, at that time, will need to make that record in the event that that becomes a problem. If that becomes a problem, if anything, I don't think the applicant would want to make that position.
We could, in theory, we could withdraw and reapply on January 2nd.
Right.
You could, yep.
It's really not, I've had this debate with many land use attorneys, but I get it.
It's something that just should be, I think,
Yes.
should be addressed, and, because we don't want to just wait to the vote and then have a problem.
No, so we'll wait to see what you choose to do, and then we'll react accordingly. Okay, thank you. Okay, if we could, we're going to continue now, please, everyone.
We need 5 people out there. They would need 4 people to approve. January 1st, you can have 4 as approved, and then 3 people need to say yes to approve.
But
What's that?
the law changes to make it easier, right?
Okay, moving on.
Yes.
Item 7B,
Yes.
Storage Rentals of America, application requesting approval to construct a 3-story approximately 61,200 square foot self-storage building, 104, on lot 104 in a Bisney Highway, VH zoning district in the Water Supply Protection Overlay District. Is the applicant present? Before we,
You wanna just take a short 1 minute break, just so she can clear out?
yeah, okay. Well, no, I think, I think we can, though. If you go to the podium, sir, if you could. Because what I'd like to do is before we introduce the application, there's two items that I want to discuss. One was, we know that we appear to have a defective application or defective notice in as so much as 5.1 was advertised for part of the relief in the watershed, when in fact it's supposed to be 6.19. And the second item, which, you know, we can get past that as long as you're aware of the fact that, you know, we would proceed, folks, if you could, please, that we would proceed that way. But more importantly, you have submitted absolutely nothing that complies with 6.19, which is what you're seeking relief for. And unless I'm wrong, I see no documentation, no memorandums, nothing from any engineer that complies with any part of 6.19. And I'm almost of the opinion to suggest that you continue this to a date certain so that you can address 6.19, because unless you can tell me that I'm wrong, I don't see it.
I can't tell you that, but can you just be more specific? The plans were submitted and,
Well, 6.19 is the ordinance that deals with the watershed and the special use permit that has to be granted in accordance with 6.19 is different than a normal special use permit. You're asking for two. You're asking for a special use permit for the use, because it's required. And you're also asking for the special use permit that's tied to 6.19, which is the watershed district. But in reviewing 6.19, the ordinance, I don't believe that you've provided any information at all to the board that shows compliance in any way, shape, or form with that. And of course, if we need to proceed without it, it's not beneficial. So are you aware of this or not aware of this? Your engineer should be.
I'm filling in for the project manager on the
Okay.
project.
Well, I mean, I can introduce everything into the record, but honestly, if you want, why don't we do that, and then we can go to your civil drawings. But again, I saw nothing in there, and if you're not even aware, are you aware of 6.19?
Not all the specifics. I'm under the impression that we submitted everything that needed to be submitted.
Well, let me do this. Why don't let me submit into evidence what we have, and then you can look at your civil drawings. The architectural drawings are moot. They don't really mean anything with regard to the matter that I'm discussing. So, for this application, we have P1 is the ZBR application dated 22-6.
Mr. Chairman, if you don't have it, I know, I spoke to the engineer that did it all, or my name is Bill Raish, I'm VP of Development with Storage
Yep.
Rentals of America, we're the applicant.
Yep.
With the property under contract. I did speak to the engineer who had done all of the work, who reassured me that all of the 619 detail was done. It appears it has been submitted to you. If you don't have it, then I don't want to waste everyone's time putting this all on the record when we should probably just continue it then.
Well, let me put it on the record because you don't have to withdraw. All you have to do is get a continuance.
Yeah.
So why don't I put it on the record?
That's fine.
And if we are in error, then they can show us where we're in error. So let me get it into the record, and then we'll take a brief moment.
If I stepped out while you're doing that,
Go ahead.
call the engineer.
Go ahead. Yep, that would be helpful. So P1 is ZBR application 22-6. It's dated December 13th of 2022. It's our standard application.
The only thing, Mr. Chairman, there's 20 pages, there's 2 page 19s on that. It's the authorization for representation, so I guess there's 2 people who get represented, there's 395 Eddie LLC.
Yeah, well, that's all right. I mean,
It's just for the
yeah,
record.
it's part of it.
Yep. It's 20
And I would note that, you know, if you're going to revise, you should note that you filled out, I think you also filled out the variance as appendix or attachment, and you don't really need to, since it's a special use permit, not a variance.
Do you want to mention something on
No, no,
more
let's,
specific?
yeah, but what do you mean on?
Well, because they're not specific.
Yeah,
on what-
well, I had discussed that already, that the advertisement and the application, in fairness to our zoning official, was submitted as to 5.1. And again, our ordinance might be a little bit circular, where it could chase you away as 5.1, but it really intends to be 6.19. So if you're going to modify the application, you should reference 6.19. That is the ordinance that applies to the overlay water district.
Does the notice have to be,
Well, we would resubmit
You would
since we're
resubmit,
continuing, so, but if you can update your application, then that would facilitate matters, and that would reduce or eliminate any ambiguity. So P2 was your radius address. P3 is a warranty deed received for the record on June 17th of 2016. And that's for 395 Eddie Dowling Highway. P4 is another warranty deed, and that was received on November 4th of 2020. And that's for 435 Eddie Dowling. Oh, no, that's the Realty Trust. Yeah, I'll see if you can find the address.
Why these don't-
Yeah, I don't know why the second one is always confusing. P5 is, I believe it's 21 pages of site photos. It has an attachment cover letter. It says 395 Eddie Dowling, North Smithfield, Rhode Island, site photos dated 9/12 of 22 by Nancy Rosenblatt. Oh, that was in the packet. I had just found that cover letter. It was,
Pages, these pictures go
yeah,
with that?
yeah.
So what's that, P5?
That would be correct. P5. P6 is the 200-foot radius map prepared by Kinley Horn, and it's dated 9/15 of 22. That's P6. P7 is the architectural drawings prepared by MSSI Design LLC. Issuance date is 8/11 of 21, and that's the architectural. And P8 I have as the civil drawings, which was prepared by Kinley Horn, has a registered professional engineer, civil stamp, estate of Rhode Island, number 8946, and it's dated 9/26 of 22.
5/19/22.
The issuance date,
You have this date right here?
what's that? Issuance date is 9/27/22.
Right on this page?
Zoning Board of Review.
Okay.
So that's all we have, and then we have two items from the town This is the planning board decision, we'll call it T1, and that date of record was September 6th of 2022. It's from the Town of North Smithfield Planning Board. It's titled Decision. It's to Storage Rentals of America, 395 Eddie Dowling Highway. That's with regard to master plan approval. T2 is a memorandum, also from the Town of North Smithfield Planning Board, to the Zoning Board of Review. With regard to, this is their letter of recommendation, indicating that it's dated August 20th of 22, indicating that the application is consistent with the comprehensive plan. So that's what we have, and I mean, unless there's an engineer who's qualified, and it's not even just an engineer, if you go to 6.19, oh, sir, if you could come up to the mic, were you able to speak with your engineer?
I did. I mean, the response I got was that the civil plans were prepared in accordance with both section 5.1 and 619. I mean, if there's something specific that we're missing, then, you know, if you could give me a little bit more color on that, but, I mean, you know.
Well, all due respect, what normally happens, I mean, members can do as they'd like, but what normally happens is that we have engineers come here and give a presentation. We're not engineers by definition.
Of course,
It's not for us to interpret a drawing as significant. This has everything, and it has topography. What I don't see is any literature, any memorandum, anything from from a professional required. If you just go to 6.19, and 6.19 has become, you know, a very important ordinance, and it has very specific requirements. And it very well may be that your engineer can come back and show us on your civil drawings how compliance with the ordinance will be met. But we also, the ordinance itself calls for documentation, a report. We would strongly recommend.
It needs to be specifically enumerated how we're meeting that statute, not just it's incorporated into the plans.
And honestly, sir, this is to your benefit.
Absolutely, no, I understand, I appreciate that.
If we're forced to rule on what we have,
Yeah.
You know, it's not the most productive.
No, that I understand, and then given the other issue, and in the meantime, we could correct the notice issue with the.
Correct.
Yeah, so I mean, it would make sense to just continue. And
I think it's to everyone's benefit. You're vested as far as the application is concerned, so we would continue it to a date certain. We can check with our zoning official as to the next available date, and then all I would do is urge your engineer, who appears to understand it, give us feedback from 6.19 that shows us the standards. You know, the analysis and all of this final design is a bit excessive, but he can find a way to communicate to us that 6.9 would be compliant.
We'll dig back into the statute, and if we need to follow up, we'll follow up with staff and figure out, you know, make sure we have what we need.
Yeah, I think that would be beneficial.
Is there anything else tonight? Is there anything else productive that we can do here? Does anyone like public comment or anything like that to address any issues just while we're here? I flew up from West Palm, sprinted across the Charlotte airport. So if there's anything else I can, I can do.
I can present what the project is.
So you've already applied with Rhode Island DEM
Yes, it's in the process.
for stormwater, and then you have,
Hold on, why don't we do this then? We're free to go ahead. Why don't we just, you're the legal counsel? So
I
just
am.
identify yourself. And then,
I'm a
sir-
civil engineer.
Oh, you're a civil engineer, so you need to be sworn in, and same with you, sir.
Yes, sir.
Just give the secretary your name, raise your right hand, and indicate that your testimony will be truthful to the best extent of your abilities.
My name is William Scully with Kimley Horn and Associates, and my testimony will be as accurate and truthful as to the extent of my ability.
Okay, why don't you give us, and then, sir, you can introduce yourself now as well.
Sure. My name is Beau, B-E-A-U, Raish, R-A-I-C-H. I'm with Storage Rentals of America. I'm Vice President of Development, and my testimony will be accurate and truthful to the best of my knowledge.
Okay. Okay, Kyle, are you able to go to the plans? So for the record, my name's, again, is William Scully, civil engineer, registered professional engineer in Rhode Island, with Kimley Horn and Associates. And as we mentioned, I'm filling in for the PM who wasn't able to make it tonight. But what I can do is give an overview of the project, go through some of the plans so that you understand what the project is. Maybe there'll be some questions that we can go back and make sure that we have that covered prior to the next hearing. The project is at 395 Eddie Dowling Highway. It's an expansion of an existing storage facility. The proposed project, as you may have read through the material prior to the hearing, is to construct a 3-level storage building on the lot 104, immediately to the north of the existing facility. The 3 levels would add about 61,000 square feet of space. The access points to the facility will be the same as exists today. The project has been reviewed with RIDOT, and they determined that no physical alteration permit is required. We'll be using the same driveways. 2 of them, they're right in, right out. And they've provided a letter dated, I don't remember the date right off the top of my head, but there's a waiver letter for no further physical alteration permit needed. The information, the plans have been submitted to DEM. No comments, no review, no feedback from them have been received at this point. And as you saw, the project has been through master plan with the planning board and approved with conditions. And at this point, the design staff as well as the applicant have no issues with the conditions that the planning board provided.
Sure, if you can, I noticed that there's the easement is uphill. Is that the National Grid easement that cuts across the highway, right?
That's correct.
So you would build downhill of that?
We are building to the, if you can, so this is the existing site.
Yep.
Top of the, top is the lot 104, and then the existing 3 buildings, you can see the rectangular horizontal shape are the existing storage facility. Eddie Dowling is to the right side of the sheet, and way over here is 146. If you can go to the, it's probably C, well, go to the C2, Carl, if you can. Yeah, so can you zoom out a little bit, I guess. So this is more detail of the existing site, and you can see the existing driveway on the north side to the existing facility. Lot 104 is what's shown in detail to the top part of the sheet. The grades run high to low, coming north to south.
Yes, that's that house that you can see from the street there.
Yeah, so there's an existing house just off the border of.
Yep.
Yeah, and there's a second structure way to the left side.
It's in the setback too, right, that house? Looks like.
The first one is.
Yeah.
Okay, so the project will, what I was going to mention, wetlands are running alongside the left side of the sheet. I should bring a pointer, that's what I need. And there's some mobile storage units also on the site, as you can see, going up and down. If you can go to C4, Carl. So this sheet will possibly show the proposed plan. next one. Yep. Okay, so part of the project will be to remove those two existing structures that are on Lot 104. This is the layout of the proposed additional storage facility. Footprint is about 20,400 square feet, 3 stories, I said, hitting about a total of 61,200 square feet, roughly. Let's see, the 2 lots will be consolidated, and in the end, the side setbacks and the front setbacks will be exceeded. The minimums will be exceeded. Right now, side setback, I think you need 15 feet, there'll be 30. And along Eddie Dowling, front setback is 25, and it'll be over 60 feet on that side.
You're cutting into the high grade because you're maintaining the original?
Correct, roughly. So right now, the grades around here are around 281, 282, and will be around 282 throughout the existing building and the paved area around it. Pavement around it's 24 feet in width. It's a climate control facility. On the left side, upper left side of the, right there, where that arrow is a proposed infiltration basin with a 4-bay proposed. That obviously is under review with DEM. It is, part of that work is within the buffer of the wetlands, so that again is under review. One of the conditions on the master plan was make sure it's submitted to DEM before you come back with the preliminary and address that, if they want changes or are okay with this, then we'll know. Let's see what else is on my notes.
Are you continuing the existing storm drainage?
Continuing, but updated up in this area. So in fact, under proposed conditions, the flow rates will be lower than they are under existing conditions. And there will be a retaining wall along from about the middle point of the building to the back towards Eddie Dowling. As you mentioned, we're cutting, so the top of that property is somewhere around 295, 296, 297.
How much of the upper bed will be yours? Will remain, will just be graded off from vegetation, or are you going all the way to the?
I don't know off the top of my head. Let's see. All right. We're not changing anything flowing out into the RIDART system. And as I mentioned, the flow rates on site, everything else will be on site, the flow rates will be lower than before, and that's an infiltration basin to meet some of the requirements of DEM.
Are you also probably upgrading the existing infiltration system to current?
We're not, so anything that we're doing is, see where those dots are around the building? That's approximating the level of disturbance. So we're not doing any more work south. Right.
And from the street, because you're cutting in, right? You have a 32-foot, I assume the high eve is on the highway side?
Correct.
Okay, so as it's cutting in and the road is going up, are you ever at the point where you do the roof? Not that that's relevant, I'm just curious.
I don't know. I would say probably yes. We need to be below 35 feet, and we are, but if we're around 295, 297, 298 going up, and we're at 282 ground level, 35 feet puts you at 300 feet or so. Planning board has asked for a certain treatment around the sides of the building from a design point of view and aesthetic. But But again, on the site and from the north, it will largely be not visible until you get really down to the site itself. Oh, go ahead.
Can I answer that?
Mhm.
We actually are launching a huge solar initiative with the company to put solar on a lot of properties. The design of this project got started a while back, so it hasn't been incorporated in this plan, but if it doesn't get into the building plans, it'll get retrofitted on after. We are launching solar across the platform.
Yeah, and I think that was raised as in one of the conditions in the master plan process too, having the building structurally capable to do that.
Yeah, we're having all the architectural be designed to be able to hold up solar, so.
So your biggest electrical load would just be the cooling?
Say again?
Yeah.
Your biggest electrical load would just be?
Oh, yeah.
Be the cooling,
HVAC
yeah,
system, yeah. We use all LED lighting and everything, so minimal electric drain other than the HVAC systems.
Let's see, just seeing if there's any last minute things. We won't have hazardous waste, toxic waste, anything like that on. So in terms of meeting 619, the engineers did go through some things, and I think as we talked, we need to write that down on paper. So it's all there.
Contract for people that rent, so it's rental to store stuff, right? So you have contracts that are in place that tell the person that's renting?
Yeah, we do. We have a standard lease agreement that's been vetted by, industry professionals, that limit what you can store. Yeah, I mean, obviously, we're not there policing whatever puts in their units, but, yes, you're not allowed to store, any noxious chemicals, gasoline, just.
Would that be beneficial having it 619? Is that?
We can include a copy of our standard lease.
Yeah, so we're not having petroleum stored out there. We're not having, in terms of most of the construction's all cut, not fill. So we're, again, with 619, you can't bring in fill that's unclean, and we're not going to have that issue. The fire department has full access.
She texted you the memo we need.
No, but I think she did a lot of it, yes. Portions of it. Impervious surface is going to be below the criteria that is in the regulations now. So anyways, I think you get the gist of what the project is. We're trying to minimize any impact on the wetlands and the buffer in the stormwater. We recognize the situation where we are. The use permit, the use is allowed in the business highway, but needs approval by you. DOT concurred. It's not a traffic generator, and it's not anything substantial that's going to change anything on the street. So it looks like between now and before the next hearing, we'll put that memo together that supports everything that we've given you already.
And if you could, with regard to one of the criteria for the special use permit for screening and buffering, if you can check with your architect or maybe give us a visual as best you can of the building cut into the hill and the topography of Betty Dowling Highway coming down and what it may look like with regard to screening and buffering. I know that the architectural showed different veneers and.
I'll talk to my, I know we discussed, you will see some of the building, but it will be concealed pretty well, but I think you can do that where we can kind of put put it like an actual image, where you kind of see,
Yeah.
Just an approximate.
Yeah,
Yeah, I'll work that
yeah,
out.
because we have the renderings of the buildings.
Yeah,
It may be in your package too,
On
so.
a street view, yeah.
Oh, feel free, you can bring that with you if it's gonna help, so.
That's all blacked out around that, I presume?
Correct.
Well, that's required so that you get the drainage.
Yeah.
Into the man. And your parking is minimal.
Yeah, we have erosion controls in this set of plans during construction. And landscape plans will be detailed, and more the drainage. Planning board, it's a master plan, so we've got the overall. So a lot more detail will be provided, assuming that we get through. We can't go back to planning board until we're done here, as well as DEM.
And the last question I had is if you can, when we come back, just give us a good understanding of what the uphill side will look like, you know, when it's
I know anything within Lot 104 today that's not part of that building area and where the wall is, from that point on, it's all staying as is. Yeah. Minus the, taking down the existing structures on that site and then,
So, any existing trees, et cetera, whatever was there will be there?
yes.
Yeah, most of the front, there's one large tree at the front that would probably have to be removed, but most of that is cleared, or it's low brush and vegetated. Everything, we're not touching the back half of the property, which is heavily vegetated, so most of where we're building is already cleared, other than just scrub vegetation.
And we can go on site. Do we need to speak with anybody if we go on site?
No, you can actually, you can actually get right onto that site, there's no gate there. I don't know, we don't own it, it's under contract, if you need to get there, maybe I can give the owner a heads up, but he doesn't care.
I mean, you can see most of it from just standing on the existing pavement in your facility.
Yeah, you can, there's kind of a large rock outcrop, there's, if you're standing in the front of the property, kind of where the existing driveway is, it kind of rises up a little and drops down, just because there's a kind of almost like a berm there, so it is hard to kind of see, you'd have to kind of walk up onto the property to see.
Good. Are we good with your presentation?
I'm good, thank you very much.
Okay, do we have a date certain that fits? Well, I'll open it up, we'll do it in a second, just want to know what the date certain would be.
As long as they can get it prepared in time to get it noticed, we can go and get all your documentation and engineers and all that stuff. We can do the 24th, and we'll be bringing both cases from tonight to that same date.
Oh, 124?
Yep.
Does that work for you?
You want to text Kelly, she's listening, just text her, make sure she, I don't want to tell you that.
Yeah, okay. While you're doing that, do we have any member of the public that wanted to speak on this matter?
For or against?
No one? Okay, we'll keep that open until the next meeting as well. Why don't you take a moment and check with your engineer?
And we'll have to renotice it and go through the whole thing again, so.
How long is the notice?
It has to be advertised, and it has to be 2 weeks, 2 consecutive weeks prior to that meeting. So don't have a whole lot of time, that's why I'm asking.
But the document, how much time can you need to have that prior to
We prefer a week if possible, so we
Yeah.
can get this.
What's the next hearing after that? You're saying the 24th isn't?
The 24th of January would be the next one you could get on, or if not that one, you'd have to go into February, and it's the 2nd and 4th Tuesday of the month.
She's available on the
She said she's got all this, she just didn't have it in memo format, so that shouldn't be an issue.
So we'll take the.
Yeah, that's plenty of time, yeah.
So why don't we have a motion to continue this application to a date certain of 124?
I'll make a motion to move this application to a date certain of January 24th, 2023.
Second?
Second.
We have that, all in favor? Aye. Thank you very much. We'll
Thank
see
you,
on
I
the
appreciate it,
24th.
thank you very much.
Mr. Chair, just so these applicants are also aware of the law change, as of today, until the end of the month, you need 4 votes to pass an application. As of January 1, 2023, you need 3 votes. Now, the previous applicant is considering doing a technical refiling and before the 24th, so that there will be no confusion about the date the application came in. So you may want to talk to your attorney about that. Nobody knows, I just don't want you to be here on the 24th of January, and the position is that you need 4 votes because it's predates the law change.
It relates back to the date of filing, not the date of the vote.
I think that's the general rule.
Yeah.
The general rule is you're vested as of the date you filed, not the date of the vote. So,
File on January 2nd.
but that's exactly what,
Actually, meet the January 24th.
I think you could. In these circumstances, you could.
As
You-
long as everything's in order.
And then what you would do on that date is ask the board to incorporate any testimony and documents from this date onto that, so you basically would be right here again, but only have to get 3 votes.
Okay.
So, again, I'm not giving you legal advice. I'm telling you this is a legal problem, and you should consult with an attorney, and you should decide. I'm not telling you to refile, that's up to you.